case briefs, and so much more. LSData's got what you're looking for.
In 1898, the New York Supreme Court, Appellate Division, heard the case of McNevin v. Solvay Process Company, which revolved around an employee's right to receive a share of a pension fund established by their employer. The plaintiff, a former employee who was discharged after 5 years of service, sued the defendant for $52.54, claiming it was his rightful share of the pension fund. This fund was created voluntarily by the defendant to benefit its employees, using a portion of its profits unrelated to wages. Control of the funds was left to the defendant's trustees. Central to the case was the question of whether an employee had a legal right to the funds before the employer decided to pay out, according to established rules and regulations. These rules stipulated that payment could be made to retired employees, those who had served for a certain number of years, or those discharged without cause. The trustees could also withhold payment in specific circumstances, such as if an employee divulged the defendant's processes after leaving the company. The court ultimately determined that the lower court's decision was incorrect and needed to be overturned, calling for a new trial and reimbursement of the appellant for any costs incurred. The majority of judges, with the exception of Green and Ward, agreed with this ruling, confirming that an employee does not have a vested right to a pension fund until the employer decides to pay out, according to the established rules and regulations.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.